Having done my scene setting, as it were, I was going on then to address you as to the first of our grounds. It was our alternative ground below what we're calling the enforcement ground. And as you'll have seen, that's the basis that found favour with Mr. Justice Jacobs. This obviously, everything I say now in this section of my submissions is assuming my learned friend is right, that the children heirs can't be joined to these proceedings so as to seek substantive relief against them. And therefore, in our alternative, we seek their joinder as defendant parties, as we've been discussing in the mornings, so that they are in some sense bound into the outcome of the proceeding. There's obviously nothing random about that approach being taken by the judge below. I've taken you to, and we've seen Professor Jacob's uncontested evidence that they have indeed succeeded to his liabilities under Swiss law automatically. And we've seen that from a Swiss perspective, the English court undoubtedly has jurisdiction over them. But it's also the case that the Swiss court requires formally that they be named as defendants to the action in this jurisdiction, which gives rise to a judgment establishing the relevant liability. And in that respect, I could perhaps just take you to Professor Jacob's report again, to the questions put to him and to his response, which is in the supplemental bundle, page 146. There is, in my submission, and as we'll see, in a sense, a formalistic requirement of Swiss law in this regard. So you'll see on page 146, at the top of the page, we set out, or some questions were set out to Professor Jacob. To the extent, if any, that the Swiss court would apply Swiss law to issues of succession, would the Swiss court recognise and enforce the English judgment against deceased assets in Switzerland if, 1, the defendant recorded in the judgment is the defendant's estate, 2, the defendant recorded in the judgment is one but not all the deceased's heirs, and as we know, his widow is a defendant, and 3, the defendants recorded in the judgment include all of the deceased's heirs. And so the professor goes on to give us his views in the following paragraphs, concluding relevantly for us in my submission at over the page at 2C4, where he says what his analysis means is that the heirs must each be named in the recitals of the statement of claims as well as the judgment, because a suit in the name of the heirs of X or against the heirs of X or against the estate of X is not admissible from the perspective of Swiss succession law. And therefore, answering our questions, he says the first question must therefore be answered in the negative. If the recorded defendant is one single heir only, so that's why he says a judgment against the estate doesn't do the job. Then on the second question, he says if the recorded defendant is one single heir only, then such a judgment may be enforced against that heir and their quota of the estate, but not the estate as a whole, as the remaining heirs are not bound. And as a result, the second question must also be answered in the negative. And then he says, if the judgment lists all heirs as defendants, then the judgment binds the entire community of heirs, and as a consequence, the entirety of the estate assets can be used in its enforcement. The third question must therefore be answered in the affirmative. So what we say is, under Swiss law, if the children heirs are defendants in the English proceedings, the Swiss court regarding the court here as having jurisdiction over them, and a judgment is given which establishes Far's liability, the father's liability, i.e. establishes his acts gave rise to liability on his part, that is good enough for our purposes. We don't, and to address a point my Lord Justice Arnold was discussing my learned friend this morning, we don't suggest, and we're not in our particulars of claim seeking a declaration against the children heirs, as it were, declaring that they are liable to us.
No, not declaring that they are liable, declaring that the original first defendant.
Precisely so. I misunderstood in that case, my Lord. Yes, we would be seeking a declaration that the father, his acts gave rise to liability on his part, and it follows as night day under Swiss law that therefore the children heirs are liable in his place unless and until they disclaim his estate in Switzerland.
So what you're looking for is a judgment in relation to the liability of father in proceedings in which the heirs are all parties parties.
Yes, properly
and as a
joined.
result of that judgment, a declaration that the father was liable. And that
Precisely
would be
so.
sufficient for you.
As we understand it, that will be sufficient. And we say there's nothing inherently radical with that notion. There are obviously other situations in which parties are joined to English proceedings in the absence of any cause of action against them. We referred the judge below, and the judge in his judgment has referred to the Chabra jurisdiction, part 19.3, joined of electoral assignees and assignors. We're not saying that any of those situations are, if you like, directly comparable to our situation, but in a sense, our situation is a fortiori those situations, because we know that there is a cause of action under Swiss law against the children heirs, and that the Swiss court thinks that this court has jurisdiction in relation to that very matter. So this is simply, we say, another instance in which, properly exercising its discretion, the court can join them as proper parties. And we say, to be clear, that that flows both from 19.24a, i.e. they are also persons to whom the father's liability has passed. They are persons to whom, under Swiss law, his liability has passed, and there's no reason to read 19.4a as limited to passing under English law. And they're also within 19.22b as persons in relation to whom there is an issue between PIFs and them, because the question of whether the father was liable is relevant both to the personal representative and her position in this jurisdiction, and to them under Swiss law.
Does 19.2b refer to it being just and convenient? Desirable.
Desirable. It's purely desirable. Yes, exactly, my lord. So if the question then for service out is, well, if they were in this jurisdiction, could you join them? Would they be proper parties? Well, we say they would, because either of those provisions would permit their joinder. It would be desirable to join them. And therefore, they're also proper parties for the purposes of the gateway. And if you like, you start with joinder, and then you see if you've got a gateway, and we say there clearly is, there are two bases upon which joinder is appropriate, and if they were here, they would be appropriately joined, and therefore they can be proper parties within the gateway. If I then turn to my learned friend's objections to our contentions on this basis in his skeleton, that's in the core bundle at page 28. Paragraph 47, he says, there's simply no prospect of any order being made against the children heirs. Thus, there's no prospect of their being bound by any order, whether enforcement purposes or otherwise. As I've just said, we're not seeking, as it were, an order from the English court against them, but we say, on the basis of what Professor Jakob tells us, something less than that suffices for our purposes. So that's not an objection that runs on this hypothesis, on the enforcement hypothesis that we're considering. He then says there's no independent basis for joining parties, and the court should be extremely cautious in permitting joinder of foreign parties where there's no substantive cause of action is advanced against them. And he says at the end, in the case of enforcement against assets abroad, the questions of against whom and what assets and in what capacity a judgment of the English court can be enforced are matters which properly fall within the jurisdiction of the foreign court. Well and good so far as it goes, but there's no reason for this court to have concern in our situation about that, because we have the clear, uncontroverted evidence of Professor Jakob that the Swiss court regards the English court as having just the same jurisdiction over the children heirs as it did over their father, that they stand in exactly the same position in terms of liability as did he. The defences available to him are available to them, defences not available to him are not available to them. So there is no, if you like, comity issue so far as the Swiss position is concerned in our case, because we know exactly what the Swiss position is. And I've already said that we're not saying when it comes in paragraph 49, Then a friend talks about Chabra and the other examples. We're not saying they're on all fours with our case, they're plainly not. We're simply saying that the English courts have experience of and are capable of binding people who should be bound into English decisions in relevant circumstances, of which we say this is one. I'd like there just to deal with two points that different members of the tribunal raised with my learned friend this morning. The first was my Lord Justice Arnold's suggestion that, well, could we have joined the children heirs to the proceedings here even before their father died? My own friend understandably rather leapt at that and said, well, yes, probably on the basis of my argument, why not? And gosh, well, there's a terrible floodgates risk that then immediately ensues. We don't say that we could have joined the children heirs before the father died. Under Swiss universal succession law, the children heirs only attain any status in relation to Far's assets and affairs and his liabilities following his death. They have no interest in assets or liabilities before then. And so we say they wouldn't fall, if they were in this jurisdiction, they wouldn't fall into section 19.2. They don't fall into 19.22 because there's no issue live between them and PIFs in advance of their father dying. And they don't obviously fall within 19.24a because no liability has passed to them in advance of the father dying. So it is only the death and the consequential automatic process of universal succession which gives rise to the ability to join them to English proceedings. Therefore, the floodgates risk that we might have been concerned about doesn't arise. There was then my Lord Justice Nugee's query about whether, if there was, say, a Bahamian personal representative appointed in relation to the deceased Bahamian estate, could they not be joined simply so as to be bound to English proceedings without infringing the rule in the Court of Decision that we're going to come on and look at? My own friend said no, because that was objectionable in that it would interfere, I think he was saying, with the Bahamian court's role as a court with jurisdiction over a Bahamian personal representative. And that is part and parcel of why the English court on authority doesn't join foreign personal representatives to English proceedings. But in my submission, that doesn't follow at all. It would be a matter for the Bahamian court in that situation what it thought the personal representative in the Bahamas ought to do if an English court had joined him or her on that sort of a basis. In all reality, as I'm sure, my lady, my lords, you'll know, a Bahamian personal representative who was served out on this sort of joinder basis for enforcement purposes only in the Bahamas would undoubtedly go and get directions from the local court as to whether they should submit to the jurisdiction of the English court or not. If the Bahamian court thought that, it was a jolly good idea for the English court to, as it were, give a binding ruling which would assist in the Bahamian administration as to whether this liability existed or not. It would doubtless give a direction that there should be submission to the English court and then would expect the Bahamian personal representative to follow any English judgment in relation to the liability. If the Bahamian court, on the other hand, thought this was an offensive infringement of Bahamian sovereignty, it would direct the Bahamian personal representative to have nothing to do with the English proceedings and would tell him that he should ignore any outcome of the English process at the end of the day. So there would be, I think, nothing offensive about the English court proceeding the way that my Lord Nugee suggested. On the other hand, I accept that it doesn't happen, but the reason it doesn't happen is that foreign personal representatives are, as I'll come on and discuss when I look at the position of foreign personal representatives, are of course responsible and liable for the deceased's liabilities worldwide. And that includes, in my submission, situations in which a post-death judgment on the merits is given against an English personal representative. So obviously if the deceased here hadn't died before judgment, but died post-judgment, a Bahamian personal representative would be obligated to recognise the debt created by the English judgment. Exactly the same follows in my submission when post-death, continuing proceedings carry on against an English personal representative, a judgment on the merits is delivered. That is a judgment that the Bahamian personal representative would be obligated to recognise, because it's a debt admittedly established post-death, but it is a liability pre-death of the deceased for which he was liable. And so so you don't need to join foreign personal representatives, because if they're doing their job properly, they will acknowledge the debt, and if they don't, they're subject to the supervision of the Bahamian court, and steps can be taken to remove them if necessary, if they're improperly not administering the estate as they ought to. I'll come on to that in a bit more detail in due course.
But you supposing in that answer, I think, that the Bahamian personal representatives would be, as it were, I can't think of the appropriate terminology, but that would be the principal administration. And so the English administration would, if any, would be ancillary to that.
If the deceased died domiciled.
What if there are multiple representatives in different jurisdictions?
I don't think the place of principal administration, which in English law is determined by the place of domicile of the deceased at death,
Well, indeed.
doesn't matter in this instance. If we had a Bahamian personal representative, a BVI one, a Cayman one, a Jersey one, a Singaporean one, if an English judgment on the merits has been delivered, establishing the liability of the deceased, all of them would be obligated to recognise that judgment,
Right.
because they are responsible for the debts of the liabilities of the deceased worldwide. Those are my submissions on the enforcement ground, as it were. Nothing objectionable with what Mr. Justice Jacob did, and the appeal against what he in fact did below ought to fail. But if you're not with me on that, and in a sense whether you are or aren't, we also say that in fact we do have a good case on what we're calling the substantive ground. And can I, again, because it's helpful, my learned friend's excellent skeleton helps us, can I start with his central propositions, so I can then develop why I say they're incorrect. Again, it's a core bundle at page 24. You'll see at paragraph 25, he essentially summarises his case. He says that children heirs cannot be sued in England. It necessarily follows from well-established principles, firstly, that where there is an English PR before the court, the successors under any law cannot be joined. Secondly, there is no claim against the successors. And thirdly, that the English court cannot exercise jurisdiction in respect of foreign siticist assets of deceased people. Now, taking those in turn, it can't join successors under any law where there is an English PR before the court. In my submission, goes much further than what the cases in fact establish. They certainly establish that you can't bring English beneficiaries of an unadministered estate before the court, save in some circumstances, as my Lord Nugee raised this morning in, for instance, a Ray Diplock situation, where you can bring them from before the court to claw back assets. The cases also establish that where there is an English personal representative, a foreign personal representative cannot be brought before and sued before the English court. And I have to accept, if you like, there's binding authority on this court and on me in that regard. But they do not establish the same in relation to persons such as the children heirs under a system of universal succession such as the Swiss one. There is no authority that says that. The authorities only speak to foreign personal representatives as we understand them in English law. And I'm going to come on, obviously, as I promised you I would before lunch, and submit why there are radical differences between those two sets of persons. Before doing so, however, in my submission, it's illuminating here, as set out in my skeleton, paragraphs 27 to 29, to consider the position of a defendant to ongoing English proceedings who dies without any English assets, and so has no estate in this jurisdiction. But let us suppose he has a substantial set of assets in Switzerland, which pass to heirs there by way of universal succession. And as we know, let's also suppose that, that under Swiss law, they are subject to the jurisdiction of the English court in the same way as he was. What happens to the English proceedings in that situation? One option, which I note in my skeleton, is, well, maybe you just have to proceed under part 19.12 and appoint someone to represent the estate. The difficulty with that in my submission is it's quite hard to understand how 19.12 applies when there is no estate anywhere on this hypothesis. We know that under Swiss law, there is no concept of an estate as we understand it. And on my hypothesis, there is no English estate because there were no assets in this jurisdiction. It seems to me, or my submission rather, is that in that instance it's rather unlikely that 19.12 provides the answer. And it's much more likely that 19.22 and or 19.24 provide the answer, that there is substitution available to the court then, not of an English personal representative, because there's no English estate in relation to which such a representative can be appointed. And as I set out in my skeleton argument, I won't take you to it, there's long-standing English authority that the English courts can't and won't appoint a personal representative if there's no estate in this jurisdiction. Much more straightforward to therefore turn to the reality of the situation, which is the persons who ought to be joined by way of substitution are the persons in Switzerland who hold all the assets. So that's part, therefore, of my argument in relation to why substantively we're able to proceed against the children heirs. My learned friend's second argument here was there's no claim against successors. Well, again, we know that's wrong as a matter of Swiss law. We know the children heirs are liable in place of under Swiss law in exactly the same manner as him. If by that, my learned friend, simply means issues of succession to the English estate do not arise until its administration is complete, we entirely agree. But that simply begs the question in my submission of whether the English court can properly exercise jurisdiction over the Swiss heirs when the Swiss courts absolutely regard the English court as having that jurisdiction. And the third point was the English court cannot exercise jurisdiction in respect of foreign cited assets of deceased people. Well, we're not suggesting the English court, if you like, has a jurisdiction in relation to the assets themselves. We're simply seeking to have it exercise a jurisdiction which under Swiss law it undoubtedly has over the children heirs themselves. Standing back, what we say the court needs here to do is to recognise that under many systems of law, perhaps indeed under all systems of law, except for that of England and Wales and those jurisdictions which derive jurisprudence from it, there is no concept of the separate administration of a deceased person's assets and affairs as we understand it. And we know that English law does pay heed to the fact that a deceased person may die without assets, with assets outside England and Wales, and the fact that it may be persons outside the UK who are properly to be regarded as a primary set of persons responsible for the discharge of his worldwide liabilities. And we see that most clearly when it comes to English personal representatives being authorised to pay over the balance of an English estate after discharge of a deceased's local liabilities to a foreign administrator, including to foreign heirs under a system of universal succession. That's precisely what happened in the Achilleopoulos case, which I refer to at paragraph 32 of my skeleton. The primary place of administration in the English sense was Greece it was either Greece or Egypt, but Egypt thought it was Greece, and so the English court settled on Greece, which has a concept of universal succession, as perhaps all civilian jurisdictions do. So the English court is sensitive to and alive to the existence of different ways of administering assets in different jurisdictions already. And indeed, as I say, will order the transfer of an English estate to heirs under universal succession, where they're regarded as the persons principally charged with the discharge of worldwide liabilities. That brings me on to what I said before lunch, maybe the most important point for this afternoon, on the substantive ground, as it were. This obviously has nothing to do with the enforcement ground, but on the substantive ground, which is what I say are the very different positions of foreign personal representatives as compared to the children heirs here. As I just said a few minutes ago, I accept, on the basis of binding Court of Appeal authority, that this court won't join a foreign personal representative to English proceedings, including proceedings such as those currently going on in another court here. Whether ultimately that's a sound situation is something only the Supreme Court could perhaps one day determine. What I'd like to do in the first instance is look. My own friend took you to the passages in Dicey, so I won't refer you to those, but to look again at the Degazon decision. So if I could take you to that. Just to orientate ourselves again, you'll see on page 17 of the report that Lord Justice Carr begins by telling us that Mr. Degazon sought to recover fees for legal services rendered in Dominica to a former friend and client, Gerald Winston, who was domiciled there at his death in 1980. By a will drafted, in fact, by Mr. Degazon, Mr. Winston appointed the bank as his executor and trustee. On the 4th of September 1980, the bank was granted probate. That's in Dominica, as we learn further down, and that was the sole grant. We go then on to page 22 of the report. That's where the judgment sets out the rule from Dicey and Morris that we've looked at. My learned friend took you then over the page to the section at the top, started broadly speaking. I won't go back, therefore, to that. But in the following column, in the first full paragraph, he refers to an Albertan decision called Nova and Grove, which is also, along with this case, briefly referenced by Mr. Justice Robin Knowles at paragraph 22 of the Mozambique decision. You'll see at about, I think, halfway down C, the plaintiffs in that case were suing a range of defendants, and we're told one of the defendants sued in tort was the executive of a person alleged to have been concerned with the design or manufacture of the valve, to whom probate had been granted in Texas, and they sought leave to serve out on that Texan defendant. And then right at the bottom, the relevant passage from the judgment of Justice of Appeal Laycraft is set out, where he says, where it sought to obtain a money judgment against a foreign personal representative, all the authorities to which we referred or had resort deny the jurisdiction of any forum other than that which appointed the personal representative. And one of the points to which I shall come is that one of the key elements of, if you like, the territoriality of personal representation is that it derives from a grant from a local court. And part and parcel of the reason why the English court won't bring foreign personal representatives before it is that to do so infringes the jurisdiction, as it were, of a foreign court. He then continues to refer to some of the principal English authorities, including the one of Flood and Patterson that my own friend has put in the authorities bundle at tab 1. I think it's fair to say that what distinguishes all of the authorities cited there is that there's there's statement of the rule with, if you like, no explanation as to why it exists in the way that old authorities sometimes do, so that Lord Justice Carr goes on a little further down in D to say the more recent decision of the Irish Court of Appeal in 1918 in McSweeney and Murphy is of greater assistance, since it is also concerned with the principles underlying the rule. And then he quotes at the bottom of the page from Lord Justice O'Connor in the Irish High Court, and he says he put the position succinctly as follows. The defendant has in England the capacity of a personal representative of this deceased gentleman, that's because she had an English grant, and can be sued in England as such, but the moment she crosses the channel, she becomes a private individual. Accordingly, when administration proceedings are instituted against her in this country, they necessarily fail, that's in Ireland he means there when he's talking about this country, they necessarily fail because the defendant is outside the jurisdiction of the court which made the grant. So all of this really goes, my lords, to the limitations on a personal representative's authority and the involvement of a foreign court in the grant of authority to them. It derives, as we've seen, from a particular country's grant and operates, as Lord Justice O'Connor says here, to cloak them as personal representatives only in that court's jurisdiction. The English court recognises and respects that limitation on the role that they have taken on by a grant, and so will not treat them as a personal representative before it. It's also relevant in my submission in this regard that personal representatives, wherever they're appointed, are fiduciaries. They owe duties in the administration of the estate in relation to which they're appointed, to their beneficiaries, but also to creditors, not to waste the estate, not to cause her to starve it. And where an estate is insolvent, they owe duties to creditors even without any formal insolvency order being made under the Administration of Insolvent Estates and Deceased Persons Order 1986. In that regard, moreover, as I've already said, an obligation to recognise the deceased's worldwide liabilities, that's uncontroversial. And therefore, as I say, as I've already said, a judgment on the merits given by this court, or a court in this jurisdiction, on a claim against a deceased person which commenced before his death and concluded against his English personal representative after his death, is one which a foreign personal representative would have no basis to refuse or fail to recognise. And the claimant would have no need, therefore, to join them to the proceedings here. In that respect, as I've already said, they're subject to the supervisory jurisdiction of the court in the same way as trustees are. And so redress can be had to the local court if they're not acting in an appropriate manner, so far as foreign liabilities are concerned. The position of the children heirs under Swiss law could not be more different. There's no such limitation on the children heirs' status or role deriving from anything like a grant in Switzerland. To the contrary, substantive Swiss law simply produces the effect of automatic succession. And as we've already said, and I labour it again, from a Swiss law perspective, not only is it, as it were, there's no infringement of its sovereignty for an English court to continue proceedings against Swiss law heirs, but that is precisely what the Swiss courts consider the correct outcome, that they confer, if you like, jurisdiction on the English court in relation to the children heirs. Exactly the same jurisdiction as the English court had in relation to the deceased. And they act for themselves. They're not fiduciaries for others and are not subject to an equivalent supervisory jurisdiction to that which operates in equity here or in other jurisdictions that have a concept of personal representation. So, in my submission, the position on universal succession under Swiss law is very different to, as it were, an Anglophone conception of personal representation with only local jurisdictional authority granted by a local court, which another Anglophone court will respect. To the contrary, the Swiss court expects the English court to assume jurisdiction over the children heirs, as it had jurisdiction over their father, and as we've seen, requires indeed it to do so for the English order, any English judgment, to be given effect and to be effective in Switzerland, which, as I already said, foreign personal representatives don't require, because they have a liability for worldwide debts, which doesn't depend upon them being joined to proceedings here. So for all those reasons, and contrary to my learned friend's submissions this morning, there is a very good reason for this court to determine that heirs under systems of universal succession, or at least Swiss heirs under Switzerland's system of universal succession, which is the one in relation to which we have expert evidence, are to be treated differently to foreign personal representatives, and can, and in appropriate circumstances, should be substantively made parties to proceedings here.
How would that affect the right of the Swiss heirs to disclaim?
It wouldn't affect it at all, any more than if there was a lawsuit on foot against their father in Switzerland at the time he died. The operation of the disclaimer would operate according to Swiss law, and either it would be effective or it wouldn't. But it wouldn't, in any sense, undermine their ability to disclaim if they do retain such an ability.
But the judgment on this theory that you would seek against the heirs would be the same as the judgment you would seek against the widow, which is judgment for X $1 million.
It is. It is, my lord. I accept that. And what would have to happen, therefore, is either those issues about whether they wish to disclaim would have to be determined at trial, or there would have to be a hiving off of them under the terms of the English order, i.e. the English order would be without prejudice to such rights as they have in Switzerland to disclaim, which would seem to be the most efficient way to deal with it.
No question as to this. I mean, the heirs are currently parties to the action. The action is currently
They are. They have submitted to the. They have, subject to their jurisdiction challenge, as it were, submitted to the jurisdiction. They have pleaded
I don't understand that formulation.
No, it was a totally incorrect formulation.
If they're challenging jurisdiction.
They have taken part in the proceedings
Under protest.
Under protest, but as I understand their position, that they accept that they are here, as it were, if this appeal fails.
Well, they have to.
They have to,
That's
exactly.
recognising reality.
No, exactly. What they've then chosen to do is plead a defence which simply pleads that they shouldn't be here. They haven't gone on and pleaded anything to suggest that they wish to run any arguments different to or other than the arguments being advanced by the second defendant, or the personal representative, the widow, in relation to her position.
And pragmatically, if the appeal is dismissed, they may simply adopt the arguments of the second defendant.
Yes.
So what?
Well, so what? Quite. Absolutely, my lord. We don't cavil at that at all. That's what we anticipate they will do.
But they've not sought to bring into these proceedings any question of disclaimer.
They have not. No.
Yes.
Not to date, at any rate. No. I haven't as yet, my lady, my lords, addressed the Viegas and Cutrale, if that's how you say it, decision, so I should do that briefly. I've set out our principal position on that in paragraph 38 of my skeleton, so I shan't simply reiterate that. But it follows in my submission from what I've said about the distinction properly to be drawn between personal representatives as understood across jurisdictions deriving their jurisprudence from this jurisdiction, and heirs under at least a Swiss system, that nothing in Viegas militates against the case I'm putting. In particular, firstly, whilst Lord Justice Nugee referred to the payment of debts as being part of the law of administration and not a succession, both paragraphs 120 and 123 of his judgment, that, of course, whilst correct as a matter of English law, does not, in my submission, preclude or prevent an English court from recognising how, under Swiss law, the responsibility for father's debts transfers to the children heirs. And it remains the case that the reasons why the English court will not assume jurisdiction over a foreign personal representative do not apply to heirs under Swiss law. In any event, of course, Vegas was looking at the other...
I think I understand that up to a point, but at what stage in the analytical framework does Swiss law come in? Because you first of all have to ask yourself, well, what is the applicable law that gets you into Swiss law? What is the question on applicable law that results in Swiss law being the answer?
I think I understand your Lordship's question. The way I approach it is this: well, just taking the question of can you join these defendants you'd like to join to these proceedings? You look at Part 19, and in my submission you find two routes by which their joinder is appropriate. They have, under Swiss law, succeeded to liability, and there's no reason to read 19.24a as limited to succession under English law.
Yeah, but that CPR point 19, to state the obvious, is part of English procedural law.
Yes.
So maybe you can join them from an English procedural law perspective. But insofar as your argument depends on Swiss substantive law, at what point does Swiss substantive law come into the equation?
It comes in right at the outset in this sense, which is that the children heirs under Swiss substantive law are liable in the shoes of their father in exactly the same way as he was to the claimant. So that they are as liable as he was during his lifetime for the acts that he committed, the torts and breaches of contract that he committed.
But that may well be what Swiss law says. Indeed, that's the uncontroverted evidence. It's not an issue.
Yes.
But it's still not an answer to the question.
In that case, I'm failing to
how
answer
do
the
you
question.
get to Swiss law? I mean, fine, that's what Swiss law says. But what I'm trying to understand is at what point Swiss law becomes the applicable law rather than English law.
There are at least, if you like, two applicable laws post Farr's death to the question of is he liable to PIFs? Well, there's not. That's wrong. The causes of action.
Let's start from basics.
Yep.
The claim against the deceased is a claim in tort applying English law.
Yes, I think I didn't realize it's just English. Is it just English?
I thought it was a claim
I thought it was
under some
Kuwaiti.
foreign law.
I thought it was a lot of laws.
Yeah.
In fact, yes.
It's Kuwaiti law.
Kuwaiti law.
Although it depends on when the tort took place, because at an earlier period there was a double actionability rule, and then there was a private
down.
law.
Well, this is the reason I'm here, so I better have the answer to this. There is an alternative claim under Swiss law that is made because various of the defendants, including the first and second defendants, say Kuwaiti law doesn't apply, but Swiss law does apply. And then in certain more discrete respects, potentially Bahamian or English law might apply.
All right, but I'm grateful for the correction and clarification. That's helpful. But claims are made in tort dealing, whatever, under those potential laws, depending on which one turns out to be the applicable law as found at trial. And as Mr. Norbury explains, on one permutation, maybe Swiss law is indeed one of the laws. But let's assume that it's Kuwaiti law, for the sake of argument, that turns out to be, at any rate, the principal law that is applicable to the substantive claim. So, and let's then assume you're successful. So you've got your judgment from the English court applying Kuwaiti law. And on that hypothesis, when does Swiss law come into it?
It comes into it when we are then looking post-death at who has responsibility for that liability. And under English law, in relation to the English estate, we all accept and agree it's the English personal representative.
Yeah.
Under Swiss law, we all accept and agree it's his heirs by automatic succession. So if he was liable on that Q80 claim during his lifetime, on his death, his English personal representative is liable in England in relation to the English estate, and his Swiss heirs are liable in Switzerland under Swiss substantive law. That's all completely uncontroversial. The question is just, when judgment hasn't been rendered at the time he dies, who can be brought before the English court between those two sets of persons? My learned friend says only the English personal representative. I say no, but both sets of persons can properly be brought before this court. And that's the kernel of the argument.
Yeah, but the argument on joint depends upon Swiss law being the applicable law. And I think, what I'm grappling with is, by that stage of the analysis, you are inevitably into questions of succession. And how do you plead the Swiss law in relation to that?
We're not into issues of succession as an English court would understand them. Succession, if you like, hasn't happened in the English sense in Switzerland any more than it has in Switzerland any more than it has in this jurisdiction. You have a totally different legal architecture in Switzerland, where we don't have estates and administration and succession after administration. You have a body of persons constituted at death instantaneously as persons who inherit immediately everything, good and bad, assets and liabilities, in a way which is simply wholly alien to the way that English law proceeds. And my own friend says, well, that's an end of the matter. English law is not sophisticated enough to grapple with that situation. And if gross injustice arises, as he fairly and rightly conceded this morning, well, that's hard luck. My submission is, no, the English law is perfectly capable of addressing and coping with what happens so as to ensure that injustice doesn't result as a consequence of the severance of assets and liabilities from a unitary whole whilst a person's alive to dispersal on their death, for all the reasons that I've been submitting this afternoon.
Might it be helpful just to remind ourselves of the way you plead it?
Certainly. That is in
page 140, 12A.
core 140, yes, thank you. Thank you very much, my lord. So as my learned friend took us to this morning, we put it on these two.
And what you're arguing
bases.
now is paragraph A.
Yes, exactly. That's what I'm arguing now.
And you say you plead the relevant provisions of Swiss law, and what you say is let's leave aside administration, because that's at least confusing, if not actively wrong. And that doesn't matter. Assuming that Mr. Rajaan was indeed domiciled in Switzerland when he died, then what you say is the liability passes to the children heirs by virtue of Swiss law.
Yes, precisely, my lord.
Can you just explain, I mean, I should know the answer to this, having read the papers, but momentarily escapes me. Why is it predicated on the first defendant's case as to where Mr. Rajaan was domiciled, rather than it being a positive case of your own?
Because at this point, we are not committing ourselves to that being a correct hypothesis.
Yeah, okay. But are you advancing any positive case as to where he was domiciled, or are you simply unsure?
We're not advancing a positive case.
Right.
I've not understood why it makes a difference. Suppose you were domiciled in England, didn't leave an English will, he did leave a Swiss will, which purports to dispose, presumably, of his worldwide estate. What would English law do in those circumstances? Would it not give effect to his Swiss will?
That's what I say would happen. I think that's not entirely uncontroversial as between me and my learned friend.
Right.
But we say yes, the English court would respect, save insofar as, obviously, we're dealing with immovable property in England, were there any, the Swiss will would be determinative. Because you can...
It might be helpful if I just explain why there is some element of controversy there. We say, and this is supported by passage of dialogue you don't need to go to, that you cannot choose the law governing succession.
So if he was domiciled in England, then it's English law.
It would be English law, exactly. And so if you put a will, as Mr. Rajaan did, saying, I say I'm domiciled in Switzerland, and I say that, and I choose Swiss law, as of course you can do in other jurisdictions pursuant to the succession regulation, that won't have effect in English law. English law will identify as a matter of analysis what your domicile actually was, and then it will impose that law on you. So if contrary to what Mr. Rajaan thought, he was in fact domiciled in England, or wanted or said, then English law will apply.
And the reason we say that doesn't matter, just to be clear, is that if he is domiciled in England, England allows you testamentary freedom. So you can say, I will leave my estate in the following proportions to these various heirs, or you can say, I'd like to leave my estate according to Swiss forced heirship rules. That's not choosing Swiss law as it were to usurp English law. That's just identifying the terms of your testamentary bequest under English law. You could say, I leave half to my wife and a quarter each to my two children. Or if that's in fact how forced heirship works in Switzerland, you can just say, I leave my estate in accordance with Swiss forced heirship provisions. You're just choosing who gets what. You're just doing it by reference to a system of foreign law.
If he was domiciled in England, who would have title to his Swiss movable and immovable assets? Not the English administrator. No,
because they only have title to the English ones.
They're limited to the English estate.
Yes.
So on your case, who would be entitled to his Swiss assets?
I'm not sure off the top of my head I can give you an answer to that, Lord. I'm not sure it matters for the purposes of our debate. If you tell me it does, I'll think about it harder, but I'm not sure it does.
Well, what we're on at the moment, if I've understood it correctly, is you're seeking to obtain a substantive order against.
Yes, as well. Yes.
You've shown us a pleading which says if he was domiciled in Switzerland, then they're liable.
Yes.
But you don't accept he was domiciled in Switzerland. So what happens if he was domiciled in England?
Well,
Would they still be liable?
We go on at BB in the pleading. The numbering is slightly unfortunate. Say further alternatively, if he was domiciled in England, the Swiss court would apply English law to issues of succession in the case of Swiss movables, and English law would, on the first defendant's case, follow his selection of Swiss law in his will.
But that's succession to, A and B is succession to immovables and movables. They don't repeat what you've said in A, that they would be liable as successors.
We don't, you're correct.
But is that what you mean?
I'm not entirely sure off the top of my head, my lord. Again, I'm probably being dense. I'm not at the moment understanding how this goes to this B, if you like, all falls within the enforcement ground.
That's what I thought.
Yes.
So your claim in A
is
the only one which seeks to make them substantively liable.
Yes.
And it's premised on the assumption.
It's premised on an assumption, which is his English personal representative's case, and was his case by way of his declaration in his will that he was Swiss domiciled. So his English personal representative says he's Swiss domiciled. He left a Swiss will declaring he was Swiss domiciled. It may be that he's very likely to be Swiss domiciled, but we aren't at the moment committed to that position.
But on this pleading, unless that is the position, you don't have a claim against the children heirs, a substantive claim against the children heirs. If I've misunderstood it.
No, I think that you're correct, and that is an issue, therefore, ultimately for trial.
But I presume part of the reason why you say that's academic is because, first of all, Mr. Rajaan seems to have thought he was domiciled in Switzerland, or he's wanted that to be the case.
Yes.
And you rightly point out that's not determinative under our law. But perhaps a little more importantly for our purposes, if I've understood correctly, the children heirs aren't advancing any different case either.
They're not.
So they're not saying, no, he wasn't domiciled in Switzerland, he was domiciled in England.
No, they're not. And one of them, not the children heirs, but one of the heirs, who's also the personal representative in England, does say he was domiciled in Switzerland.
So when you
That's
get...
the wife.
The wife, yes, sorry, yes.
So it may be in one of these situations where, in fact, even though you're not advancing a positive case, one could proceed on the assumption that this will be the case, because there's actually nobody is advancing a different case at trial.
At the moment, as I understand it, no one is advancing any case at trial for any other domicile death for the first defendant, other than Switzerland, which is the case of the personal representative and his wife.
Okay, where does that leave us?
I think and I hope, my lady, that leaves us fairly close to the end. We'll be relieved to hear. I was going on, I think, to yes, just to conclude on Viegas and Cutrale. There's the obvious point that it's the opposite situation to ours. That was a case in which the court was grappling with, well, who can bring proceedings before the English court post-death? We don't cavil for a moment with the reasoning of the Court of Appeal in that scenario. For the reasons I set on my skeleton argument, the English cause of action is an English citus asset. It vests in the PR and nobody else. They are the person to bring that claim in this jurisdiction. It wouldn't, on my case in our situation, be an asset vested in the children heirs. There's nothing to do with them under Swiss law. And all the policy reasons or practical reasons that Lord Justice Nugee identifies in his judgment at paragraph 125, which supported his decision. If we just look at those very briefly, the case is at page 392 of the authorities. And I think we want paragraph 125 on page 433. He says his conclusions that only the English personal representative could bring the claim in England are supported by practical considerations as well as principle. And if I just ask you to read that paragraph. All of that makes perfect sense in my submission when you are looking at the issue of who who should bring a claim after death before the English courts. And the most powerful reasons, it seems to me, are those which go to the defendant's position and their ability to get good receipt for payment of a judgment debt or settlement of a claim. None of that is relevant the other way around. None of that is relevant to who ought to be joined to proceedings, as it were, against the deceased person. And for all the reasons that we've canvassed, that were canvassed with my learned friend, and he was very frank about this morning, and that I've discussed with the tribunal this afternoon, there are very good reasons why it shouldn't be the case. It should be the other way round when it comes to our situation. There is a real risk of injustice arising if persons such as the children heirs under Swiss law can't be brought before the English court. Practically, it's highly unattractive, if my learned friend is correct, because you do then require a multiplicity of proceedings, at least in every jurisdiction where there's a system of universal succession. As I said before, you ought not to in a system where you have personal representatives, because they ought to be recognising worldwide liabilities whether they've been joined proceedings or not. But it is practicably undesirable for a result to be reached whereby after a trial of over a year in this jurisdiction, in order for, and let's assume my client's case is a good one, that it is a victim of a very serious fraud, that after a lengthy trial and an inordinately expensive trial to establish liability in relation to that wrongdoing, it then has to recommence proceedings in Switzerland in order to achieve the same result so as to obtain access to Swiss assets. So, my lady, my lords, those are in effect my submissions on the substantive ground as well.
Thank you.
I can then be extremely brief on section 1140. And I really only have, in a sense, two things to say in relation to it. One may or may not gladden the hearts of the court, which is it may be, as it were, that you don't need to decide on 1140 at all. My learned friend accepts that if he loses on ground one, then there's no need to deal with 1140, as it were, because the relevant defendant served at her director's address here takes no point that she hasn't been served properly. My learned friend has continued happily in his oral submissions to put his case before you on what I've called the knockout basis. Essentially, he's saying my claim as a whole is demurrable, capable of being struck out, effectively. Now, if he's right about that, then we would accept that, as it were, there's no purpose in now having served the director at her address in this jurisdiction, because we simply have no claim that we can proceed with against her. If my learned friend had floated any notion that he was, in fact, running a forum conveniens argument more fully, or suggesting that the court in a discretionary way ought not to permit service out, then we would have needed to pursue the 1140 argument. But as I understand it, he doesn't. He hasn't slipped from his skeleton argument. He's essentially simply saying our claim is demurrable in ab initio. And on that basis, if he were to be right, then we would accept there's no purpose in our having any proceeding on foot against the defendant served in this jurisdiction. So that, in my submission, that may mean the court takes the view it doesn't need to say anything about section 1140. If the court thought that was unfortunate and wanted to say something about it, then I have frankly struggled to think of any submissions to make to the tribunal, which haven't either been canvassed by by the tribunal with my learned friend already, or could do better than, as I said this morning, than the Chancellor's judgment in the BJSC Bank decision, which is in the authorities bundle at page 243, paragraphs 47 to 55, which really built on the judgment of Master Marsh in, as he was then in Keyholmes, Bradford, that my learned friend took you to this morning.
And sorry, which page was that for?
It's page, it's the authorities, it starts at page 243,
243.
and then the relevant section of the judgment is at page 253.
Thank you.
It's really the whole section that my learned friend has illuminated with his blue line. I think it might be my blue line. My blue line.
The key paragraph is the conclusion at 55, because it's in that
Yes.
paragraph that the Chancellor says that he thinks that the previous cases were rightly decided in the face of an argument that he should say that they were wrong.
Yes.
And the nub of the reasoning is that where a director has provided a registered address within that section, then there is service within the jurisdiction, even if the director himself or herself is not within the jurisdiction.
Precisely so, my lord. And I think, in a sense, the burden of my learned friend's argument this morning was, well, it's accepted, if you like, something that's between me and him, that you need some specific provision in order to you need something, a specific provision, in order for the court to have jurisdiction to effect service out on effect service on someone who's not in this jurisdiction. He was particularly looking at subparagraph 3. In my submissions, subparagraph 1 is the one that essentially does the job. It simply tells us a document may be served on a person to whom this section applies by leaving it at or sending it by post to the person's registered address. That is a scheme of service which does not seek to distinguish between persons inside the jurisdiction and outside the jurisdiction. It's a specific provision directed at service of documents on all persons who provide a registered address. And then subsection 8 is rendered intelligible on the basis that my Lord Justice Nugee put to my own friend and is in this authority and all the other authorities, which is, there's a very good purpose to subsection 8, which is simply that it applies where a person gives a registered office outside of England and Wales. You are to be taken as my Lord Justice Nugee put it this morning, essentially to have given an address for service in the jurisdiction by choosing to give an English address as your director's registered address. And that applies whether you knew section 140 existed and quite what you were doing or otherwise.
If you have a contract between international parties which chooses English law and submits to a jurisdiction of the English courts, they can, with no other connection with England, give an address for service in the jurisdiction and can be served at that address.
Yes, indeed. Yes.
But that's because CPR 6 says so, as Mr. Sherwin quite rightly pointed out.
Yes.
There's a specific provision in CPR 6. But what Master Marsh says is that Section 1140 operates outside the CPR as an alternative route to service.
Yes, which, if you like, Parliament is perfectly free to do.
And it's not suggested that Section 1140 doesn't apply to proceedings.
It
Don't
doesn't.
think that's ever been suggested.
No, quite.
1143 says in terms it applies whatever the purpose of the document.
Quite so, my lord. Unless I can assist any further, those are my submissions.
Thank you very much indeed. Mr. Sherwin?
My lady, my lords, I'm going to take it in reverse order, as it were, just so that you know where I'm going. And the first and perhaps most welcome point is I've got nothing further to add on section 1148. So I'm going to take what my learned friend called his substantive ground first. This is the 12AA ground. That my client there should be a judgment against my client's effectively a money judgment. as successors. And there are two reply points, or points in reply, that I want to deal with. The first is the point of principle that the learned friend has developed in the course of his oral submissions, which is effectively that because civil law succession is unitary, it is, quote, wholly alien to English law, and so one can therefore...
It's not merely that it's unitary, it's automatic.
Well, I'm not sure the automatic point is as relevant, because the succession, an executor named under the will automatically accedes, the assets of the deceased automatically vest in the executor.
But that of course is true, but it depends upon there being an executor appointed under a will, whereas the point about the Swiss law is it applies by force of law, regardless.
Well, I suppose, assuming there's a community of heirs on the same assumption. So, for example, if there was nobody falling within the defined people, I mean, I don't know what their equivalent of bonificantia is, but yes, but I don't think I'm not trying to quibble with my lord. I'm just saying that for present purposes, I think it's the unitary nature. So the point is that there's no administration followed by succession under the relevant foreign law.
Well, that point too, for sure, yes.
So he says that is wholly alien to the English conception, and that for that reason, the rule that I have taken the court to, and the authority that the learned friend handed up yesterday, this morning, and indeed all the other authorities, including the ones that are in the bundle, don't apply to civil jurisdictions. Because I think he does have to go that far, my lords and my lady, because I think if he doesn't go that far on his substantive grounds, then it's not clear to me whether well, I think he does go that far, doesn't he, that all civil law jurisdictions effectively are different and are treated the same. So
I think he says all those that are of a similar type to Swiss.
Yes, and I think all the ones we've seen, so there's been some discussion of Greece, there's some Lebanese ones in the authorities, etc. So that's point one. I'll just deal with that first. But I'm also going to come to try and grapple with what my lord said about when the foreign law comes in, the question that you directed at my learned friends. I think that is important on my analysis, because I say that the Swiss law never comes in, and that's sort of the guts of the way I put it in my skeleton argument. So the two ways I now put it, as it were, the rule 160 and the administration succession, I'll just deal with those briefly. As to the first, it does create, as I said in my earlier today, this distinction that you will see in none of the authorities at no point hitherto between civil and common law jurisdictions. And just as in Viegas, I'm sure I'm mangling the pronunciation, but Lord Justice Newing, we saw this earlier, he said that the very fact that this hasn't happened for however many years makes that a surprising outcome, that nobody's noticed this point before. But be that point as it is, on my submission, it's just not right, because it ignores the principled approach that this court takes to the characterisation of foreign law. So just as in Viegas, what this court did was it said, we are going to characterise the foreign law issue according to generally acceptable principles of characterisation. And we're going to say that the title to sue is characterised in English law terms as administration.
But that was an English asset. There was no doubt it was an English asset because it was a claim brought in England.
Well, my lord, I say the same thing applies to as it were, the section 1.1 point under the 1934 Act, the subsistence of a claim against the English estate. So a claim being brought against an English estate in England in respect of the English assets, that is akin to being an English law citus cause of action. It's the obverse of
Well, I understand that,
Yeah.
but my understanding is that the claimant's claim in these proceedings, the reason they want to join you in is precisely because of the deficiency of English assets. So that if they succeed, they want to be able to assert a judgment against non-English assets, specifically Swiss assets.
Well, I agree, my lord. But what they want is actually, they want a judgment in England against the English estate. They then notice that the English estate isn't enough. And so then they cast around. So they are bringing a claim in England against an English estate.
And they have to correct the defendant for that.
Yeah,
We
correct.
all agree that.
Yeah, absolutely. So
They are also seeking a judgment enforceable against non-English assets.
yes.
They don't have any defendant for that, because the evidence is that the widow is only an administrator to defend the English estate from this liability, and that the Swiss law won't give effect to a judgment against those liable in Switzerland who are your clients.
Yes. But just if you'll forgive me, my lord, breaking down the analysis, as it were, when you have your English law administrator, what is she doing? She's administering the estate, and part of the administration of the estate is identifying the debts.
Yes.
Right? And so I say that stage of the process, i.e. identifying who the correct defendant is and who's going to pay out, is a part of what English law characterises as administration. And so when one looks at a foreign law, Swiss law, one says, even though you are, as it were, a unitary or automatic or both foreign successor, what you are doing is a process we would call administration. And that's not wholly alien.
I'm sorry, this is completely alien to me as an approach to characterisation. Because one uses jurisdictionally neutral, legally neutral concepts to characterise, because otherwise you're going round in circles. To say that something according to English law is characterised as administration answers the question you're asking. We first of all have to characterise the issue in a neutral way, and then say, applying that characterisation, what is the applicable law? So you can't say, well, English law would treat this as administration,
So it's administration.
because that's what you're trying to prove.
My lord, I take your point that it's question begging, but what I say that is how where one comes to in this, because I say that under that so let just 1 second, my lord, I apologise. Can I take you to page 433 in the authorities bundle, which is in the Viegas decision? Sorry, no, can I take you one page back, 432? So this is paragraph 118. So this is where my Lord Justice Nugee does the process of characterisation. And my Lord, I want to get away from the heresy that you've identified. So I don't want you to take my, as it were, attempt to sort of drag myself up by my bootstraps. But so what Lord Justice Nugee says is, there's no doubt for the purposes of characterisation, the law of England and Wales distinguishes between, on the one hand, administration and on the other hand, succession. And then just moving on. If therefore the relevant issue is one of succession, Brazilian law must be applicable. The deceased, etc. And then you have 120. So you can just skim 119 because he's dealing directly with the Brazilian law, which is a unitary and automatic succession. Mm-hmm. And then he says, in broad terms, it seems to me that under the law of England and Wales, matters relating to the collection of a deceased person's assets and the payment of debts are to be considered to relate to the administration of the estate, and the distribution of the assets after that is considered to relate to succession. So that is what Lord Justice Nugee says the correct characterisation is.
Yeah,
Now,
but I have a real logical problem with this, because the reasoning is based upon the point that is common ground, that in English law we distinguish between administration and succession. But when you're trying to decide what the applicable law is, how does that help when alternative systems of law don't make that distinction? They only have succession.
because I think the effect of this is that English law applies its own process in characterising what the foreign law is doing.
Yeah, but that is secular. Because it depends upon an English law conception to provide the answer to the choice of law question.
It does, and that's what this authority does. And on my submission, that is.
And
how
you say it's binding upon us.
It is binding on you, my lord. But I think more than that, I'd say that that's actually how all English dealing with dead people, if I can use it in that sort of slightly clumsy phraseology to avoid getting sucked into words like administration and succession. That's how it always approaches, because we have this binary process, and because we divvy out certain steps in that process to administration or succession. That is how we approach it. So, for example, Rule 30 of the non-contentious probate rules, in order to deal with the problem that there aren't always foreign administrators, it says the person who has authority to administer the estate, and it's in the bundle, we don't have to look at it. So they use the word the authority to administer, but of course they are being sucked back into this, or administration succession, as it were, analysis. So I say that the correct, that this is binding on you, this is right. The correct approach is to say that the payment of debts are considered to be relate to the administration of the estate. And therefore, I say to you, the question about who the right person to be the defendant, i.e. to identify who what debts are owed and pay them, is always the administrator.
Isn't this why it matters that this was a case with an English cause of action about English assets? Because if one characterises the issue in terms of who can bring a claim in respect of these English assets, then you avoid a lot of the circularity with simply saying, well, this is about distinction according to English law between administration and succession, and therefore English law applies.
Well, I think it was common ground that English law didn't apply to the question of how the people in question characterised their own ability to. So they said they were heirs.
They were relying on Brazilian law, to be sure.
And so they came to the court, and the court said, look, you are not administrators under English law. You don't have title to sue under English law. And I say the same thing applies here, that they do, to put it slightly clumsily, we don't have title to defend. We are not the administrators, or rather, I suppose, it proves too much, because if we are the administrators, if we do have title to defend, then we could fall within the rule in Degerson. Because that's the problem, my lady, my lord, is that for many, many years, English courts have touched up against foreign universal succession without necessarily in all cases, and I know there are cases where they get applied, but without necessarily grappling this. So the Akilopoulos case, if I'm again mangling that, is a case where the court says in terms, it doesn't matter whether you've got universal succession or English type administration succession, because you just pay out the money to these people. Because that was a question about identifying whether the personal representatives in England would have obtained a good receipt. So it's really a question about how the English court treats its own personal representative. But that was an example factually of the English court meeting the foreign position and saying, well, we can just, it's not so wholly alien to us that we can't understand it and give effect to it in our own terms. And what my learned friend's argument has to do, is to say, well, that's how we treat our own common law jurisdictions, But actually, insofar as it comes to civil law jurisdictions, it's open season in the sense that all foreign successors can be joined to proceedings where a person dies for the entire suite of relief against them. They are proper persons. Because I don't see how it's limited. It's always going to be the case. And that's what the rule is intended to avoid. Now, my learned friend gives certain policy reasons for that. He says that that's because the foreign personal representative has a grant from the foreign court and is therefore liable to the foreign court. But it's also the case that there are foreign assets. They are assets subject to the foreign court. And that's because the English court only ever gave authority pursuant to the grant to assets that are either in England or have come to England. So the distinction, it's not a relevant distinction. And indeed, what my learned friend says is that, well, you don't have to worry about common law personal representatives because they're always going to just do the right thing and pay up. A, that's completely unrealistic. But B, what if they don't? You sue them in the Bahamas, you sue them in BVI. So he accepts the logic, I think, of that you have to go and sue them in those jurisdictions. He just thinks that because they're fiduciaries, they will mostly play ball. And I say that that's not an assumption that you can make in order to create this novel distinction between civil and common law. I think that on my submission, the correct way to look at it is to say whether foreign law successors are treated as universal as, and one characterises that as administration. I completely accept what you will say, my lord, is, well, that's bootstrapping and you don't characterise them in any such way, but I say that that is how they're characterised. Or whether, you don't have to get lost in the weeds, you just say they are the treated as administrators, they're acting as administrators. Then you fall back into Rule 160 or whatever it is, indices the ruling dingers on it. So those are my submissions on that point. The second point, my lord, I do want to just try and deal with what you said about when foreign law comes in on my learned friend's case, because it's my submission, and I think you understand. I'm sure you understand this, but I think it is worth digging into that Swiss law never comes into play.
Well, quite.
And on my submission, that's perfectly plain on the analysis in my skeleton argument, which is that we can go to the proposition in Viegas if we need to, but I think it's common ground. English law, both as a matter of the administration of the estate and as a matter of the law, the lex fori, the law of the forum, they are just English law. And so if one goes into the administration and looks at the lex fori, who should I be joining, one never comes out of English law, such that the only order the court is going to be making in personam is going to be an order against the administrator of the English estate. And similarly, the only person they're going to join is the administrator of the English estate. I think that's just my short point on that. In terms of the example of no assets in the jurisdiction, but again, I think you come against one of these problems about verbiage, but I say that Rule 19.12 is applicable when you have a foreign domiciliary, even if they have no assets in the jurisdiction, because you go back into the point I just made, which is the law of administration, and importantly the lex fori. The English court applies its own law to its own procedure. It says, well, estate is what we call it. You go into Rule 19.12, and there's nothing wrong with that. And Rule 30 of the non-contentious probate rules says you can appoint the people who have the authority to administer the estate abroad can obtain a grant in England. And it's subject to discretion, but it's hard to see, as in our case with Miss Justice Henshaw, why an English court wouldn't at least convene the person as an administrator ad litem. They might not give a full unlimited grant if the only connection to the jurisdiction was the proceedings, but that's a good reason to give a limited grant ad litem. My learned friend slightly overreached, I think, in his oral submission. He said, you're not going to get a grant. What the rule is, and this is in his skeleton argument, is that absent special circumstances, you're not going to get a grant. Well, those are the special circumstances. Then you've got...
But what would be the purpose of joining a foreign representative under Rule 30 as administrator ad litem if you couldn't then, once you'd established liability against that administrator, make any use of it? Because there were no English assets which could be enforced against them. On your case, you wouldn't have any effect on wherever the assets were. The proceedings would be simply a waste of time.
Well, that may well be right. That may well be right. That might be the practical answer to my learned friend's point, which is that on this hypothesis, you've got a defendant who has no assets in England. He's sued in England and he dies.
He's sued in England. He doesn't dispute the jurisdiction. Yeah. You get all the way to trial. You've spent a very large sum of money on it. The judge is about to give judgment. He dies.
Yes.
Seems on your case that you just have to throw that money away and start again.
Well, I don't say that because that's what, as it were, I want. I say that because that's effectively the fact that English law has delineated, and I'm absolutely open about this, my lord.
Yes.
It stops at the channel.
Yeah. Okay.
I don't say that's as it were a good outcome. I just say that is the law as it stands, and it is binding on Court of Appeal authority on you. Both I say as a rule of beggars, and obviously beggars on the previous authorities. In terms of going now to the enforcement grounds, my learned friend made a point in respect of supplemental bundle page 147. So we're going back into Professor Jakob's report, and he said that one of the ways that you can get around the problem, if I can put it that way, of the rule in Degerson is by effectively going through the suggestion that there be a declaratory judgment binding on the heirs, but not substantively against the heirs. And he referred to rule paragraph 2C4. But if you look at the last two sentences, in particular the penultimate sentence, if the judgment lists all the heirs as defendants, then the judgment binds the entire community of heirs, and as a consequence, the entirety of the estate assets can be used for its enforcement. And I say that if that's right, if it's not just binding the heirs, but bringing in the Swiss assets, that is a breach of the rule in Degerson. It's just a disguised breach of the rule in Degerson. Because you are bringing in foreign situs assets over which the English court has no jurisdiction.
Sorry, which is the sentence you're relying on?
Sorry, it's the penultimate sentence, my lord. So, starting if the judgment lists.
Yes, so then the judgment binds the entire community of heirs. Just pause there. That's not a problem. And then it says, and as a consequence, the entirety of the estate assets can be used in its enforcement.
My lord, the as a consequence point, that is not, as it were, an incidental consequence. This goes back to what I was saying to my Lord Justice Nugee this morning, is you are not binding these people for any other reason than you are binding them qua successors under a foreign unitary law. You are effectively binding them for foreign administrators, I say. And I say that this point, the focus on the entirety of the asset, that brings into sharp relief what is actually going on, namely you're going after foreign assets, subject to the jurisdiction, I say.
I don't think there's any concealment of the fact that the purpose of joining you is to go after Swiss assets.
I completely agree, my lord. I'm not saying that it's a disguised attempt. What I'm saying is that once one recognises that the capacity in which we are being joined is solely as foreign heirs, and that we are therefore, I say, effectively being joined as either as foreign administrators and therefore barred by the rule in Degerson, or we are only as successors qua successors, and therefore you never get to Swiss succession under Swiss law. That reveals, as it were, and it's not. I'm not criticising anybody, but I say that reveals why it's barred. So we go back to my first submission. That's all. That's all.
Can I ask a similar question from a slightly different direction? I mean, one of the points that you keep on repeating, and rightly so, if I may say so, is that ex hypothesi, we're concerned here with foreign assets. And you argue with some force, well, the English court's jurisdiction stops at the border. And it's got nothing to do with foreign assets. And on one level, that seems to be quite an impressive submission, because that seems to be grounded in a very clear and recognisable principle. I mean, you referred, or was it Mr. Richardson? Someone referred to comity. But more importantly, it's about the internationally recognised limits of court jurisdiction. So the idea that courts deal with assets located within their own jurisdictions is a commonly accepted one. But what I'm struggling with still is, okay, let's assume that we start from that basic proposition. What's that got to do with this distinction between administration and succession? Because from one perspective, they're two separate inquiries. One is about where are the assets located, and therefore which courts should have jurisdiction to deal with those assets. And one might say, well, the answer to that should be the same. Whether the system of law through whose prism you're looking at this makes a distinction of the kind that we do between administration and succession, or whether it doesn't begin to understand such a distinction because it doesn't entertain it.
I agree, my lord. And I say that the way...
But in which case one might expect the statement of law in the authorities to say English courts have no jurisdiction in respect of foreign assets, end of. And in which case all of this discussion about administration and succession wouldn't even...
That is what the authorities say. I think that's common ground between me and my learned friend, that the authority of the English court comes from the grant, and the grant only covers the English assets.
Yes,
I mean, I appreciate...
But
yeah.
As you rightly say, the rationale is predicated upon this concept of a grant of authority.
Yes.
So it's predicated on administration.
Yes.
And so the whole rationale of this branch of the law, as explained in the authorities which we've been shown during the course of the day, is it's not based on territorial limits with regard to assets, it's based on territorial limits with regard to the authority to make a grant of representation.
Well, I think it's both, because I think the English court makes a grant, and the effect of the grant is that the grantee only has authority over assets which are physically located in the jurisdiction. And I say physically located, I mean obviously sitused, so bank accounts, etc., or brought into the jurisdiction. So I mean, it just is the case, and again, Flood of Patterson, which is in the authority, shows this, that if you're in Jersey, if the asset's in Jersey, bad luck. I mean, it's that extreme, my lord. And I say, you say, well, I mean, I think that is my submission. That is the state of the authorities on my submission. I'll let you, my lords, that's it. Oh, 1 second, I should check. My lords, that is.
Thank you very much indeed. Thank you indeed, and thank you to everyone for very thought-provoking and interesting submissions. You'll be glad to hear that we are going to reserve our judgment on this very important and very interesting issue. You'll also be fully aware of how matters proceed in this court. When our draft judgments are ready, they will be circulated subject to an embargo. Please look out for and obey the embargo. That's very important. We ask for corrections of our spelling and our grammar and other typographical errors, and not re-argument. Thank you. We also hope that having seen the draft judgments, you will be able to agree in order. If you can't agree in order, please put your different arguments and your objections in very short order to us in writing, and we will decide on the papers. I think that's everything. Thank you very much indeed.
Rise, please.